Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Today we're talking about a serious topic: why a court might dismiss a protective order. A protective order, sometimes called a restraining order, is a legal tool designed to keep one person safe from another person's harassment, abuse, or threats. It seems straightforward, so it can be confusing and upsetting when a judge decides to deny or dismiss one. But it's important to understand that judges must follow strict legal rules and standards of evidence. They can't issue an order just because someone asks for one. Let's break down the most common reasons a protective order might be dismissed. First, and most often, is a lack of sufficient evidence. The person asking for the order, known as the petitioner, has the burden of proof. This means they have to convince the judge that the abuse or threat actually happened and is likely to happen again. Simply saying "I'm scared" isn't enough. They need to present concrete evidence, like threatening text messages or emails, photos of injuries, police reports, or testimony from witnesses who saw or heard the abuse. Without solid proof, a judge's hands are tied, and they will likely have to dismiss the case. Another key reason is that the alleged conduct doesn't meet the legal standard required by that state's law. Every state has specific definitions for what legally constitutes harassment, stalking, or domestic violence. A single heated argument, or someone being rude or annoying, while unpleasant, might not rise to the legal level of a credible threat or a pattern of harassment. The judge has to determine if the actions described fit the specific law that allows for a protective order. If they don't, the order will be denied. Procedural errors are also a common cause for dismissal. The legal system has very specific rules that must be followed. For example, the person the order is against, known as the respondent, must be properly served with the court papers. This means they must be officially notified of the hearing. If they weren't served correctly, the case can't move forward because it violates their due process rights. Similarly, if the petitioner fails to show up for the final hearing, the judge will almost always dismiss the temporary order. You have to be there to make your case. Furthermore, a judge might dismiss an order if they find the petitioner's testimony is not credible. During a hearing, the judge listens to both sides. If the petitioner's story has major inconsistencies, if they change their story under questioning, or if it appears they are filing the order for an improper purpose, like trying to get an advantage in a child custody dispute, the judge may not believe them and will dismiss the case. Finally, the situation may have simply resolved itself. Sometimes, the petitioner themselves will ask the judge to dismiss the order, stating that they no longer feel threatened or have reconciled with the other person. While protective orders are a vital tool for safety, they aren't automatic. A judge must weigh the evidence and apply the law carefully before taking the serious step of restricting someone's liberty. Thanks so much for watching. We hope this information was helpful. If you found value in this video, please hit that like button and subscribe to our channel for more